The Electoral Commission has filed an urgent and direct appeal to the Constitutional Court to challenge an Electoral Court order on its decision to bar uMkhonto weSizwe Party leader Jacob Zuma from participating in the upcoming elections. On Tuesday, the court ruled in Zuma's favour, which meant he could contest for a seat in Parliament. However, the IEC says now it wants some clarity after the Electoral Court did not provide any reasons for its order. The Independent Electoral Commission says it wants to ensure that it fully understands the application of Section 47, Section 1 and E of the Constitution. Constitutional law expert and Director of Accountability Now, Adv Paul Hoffman, joins us now for more insight on this appeal. Advocate, thank you so much for your time today. I guess we're also seeking some clarity, just like the IEC has indicated on this matter. Please make things easier for us. Let's understand if this is indeed a constitutional or electoral matter, and how do you foresee the matter proceeding at the Constitutional Court?
Thank you for the opportunity, Alicia, and good afternoon to your viewers. Yes, it certainly is a constitutional issue. It's a constitutional issue because the basic constitutional duty of the Electoral Commission is to ensure free and fair elections. That duty cannot be properly discharged while there is uncertainty as to whether or not former President Zuma is eligible to be a candidate in the forthcoming election. The right of the people who want to vote for him is guaranteed in the Bill of Rights, and his right to stand as a candidate for election to Parliament is also one that is very hard won in our constitutional dispensation. So for those reasons, it is clear that this is a matter that should urgently receive the attention of our highest court, the Constitutional Court, and it will get the final word as to whether or not Mr. Zuma is an eligible candidate.
All right, and then Advocate, I mean, a lot of questions around the reasons that have still not yet been provided by the Electoral Court. So a lot of people are asking on what basis or grounds is then the IEC taking this matter on appeal, and can Electoral Court decisions even be appealed according to the Electoral Act 73? Who has overall jurisdiction then to rule on electoral matters?
Yes, the Electoral Court is much the same as a high court, and there are appeal provisions in the legislation that applies. But in this case, it is really a question of asking the Constitutional Court whether it thinks that it is in the interests of justice that the matter be given its urgent attention so that it can be definitively disposed of before the election. Because if it's just put into the normal appeal procedures, the matter will only reach the Constitutional Court long after the election, and then the validity of the election, the freeness and the fairness of the election will all be questionable, especially if the Constitutional Court comes to a different conclusion to the conclusion reached by the Electoral Court in the urgent application that it ruled on Tuesday, having heard the argument at the end of the previous week. So it's a very difficult timetable because the election is on the 29th of May, and by then, and as soon as possible really, there ought to be a definitive answer to the issues that are raised by the dispute as to whether or not the former President Jacob Zuma is eligible to stand for election on the 29th of May.
And then, Advocate, this has, of course, raised some concerns with many said to be questioning now the independence. I'm sure you've seen some of the news reports, the independence of the IEC by launching this appeal bid. What is your take in this regard?
Yes, I'm afraid it is a little bit unfortunate when people give off-the-cuff answers at press conferences, but whether the IEC is acting in a dispassionate manner is neither here nor there at the end of the day, because the case is being litigated, and the answer is going to come from the Constitutional Court, the answer that really counts. And I can tell your viewers here and now that the words in Section 47 to which you referred in the introduction are by no means clear, because that section says, but nobody is deprived of their eligibility while appeal proceedings are pending in respect of a sentence of 12 months or more, a custodial sentence of 12 months or more. Now, what you've got to ask yourself when they talk about sentences in this section of the Constitution is, what kind of sentence are they referring to? And if you have regard to the fact that the sentence that was imposed on Jacob Zuma was a sentence imposed by the Constitutional Court itself in that dispute relating to his failure to present himself at the Zondo Commission, that question, that issue, is not one that is appealable. The sentence imposed was imposed by our highest court. There is no procedure for an appeal. There is no opportunity to appeal, and there is nobody to appeal to, because our highest court does not get second-guessed by some other forum. So if the section says you have to be able to exhaust your appeal procedures before you are disqualified or ineligible to stand for Parliament, what was Mr. Zuma meant to do? He couldn't appeal because there is no appeal.
Yes.
Now, the Constitutional Court, when it looks at this, is either going to say, oh, but obviously those appeal provisions don't apply because there is no appeal against the sentence that was imposed, or it could say, because there are no appeal provisions applicable to Mr. Zuma, he is entitled to stand. His eligibility trumps the provisions of Section 47 because they only apply to people who are sentenced by courts which do have the problem of appeals and further appeals. If, for example, President Zuma was convicted by a magistrate's court, he could have appealed to the High Court, he could have appealed from the High Court to the Supreme Court of Appeal, and he could then have appealed to the Constitutional Court, a process that would keep him in Parliament for a good few years at the rate at which matters are disposed of in the courts. Now he can't do any of those things. So does that mean that he ought to be given the chance to stand, remembering that under Section 19 of the Bill of Rights, he has a right to stand for Parliament, and people who support him have a right to vote for him. So will those rights trump the provisions in relation to eligibility when the sentence that he has had imposed on him is one that is just not appealable? That's what the case will do when the Constitutional Court hears the argument.
Professor, you know, you've just summed up my following question, which was going to be, I mean, the court itself had said that it was deviating from normal laws in its sentence. So questions are now that this act that is being actually used to disqualify Zuma from running in elections might not be applicable in this case, as normal steps were never initially undertaken. So thank you so much, Prof. Advocate, for that clarity. That is Advocate Paul Hoffman there with some serious clarity on the IEC as well as MK Party issue.